As of today, Palestine has been inducted into the International Criminal Court. It's a move that will potentially have big implications. And joining us now for more on that, here's Rita Maxwell, former visiting professional with the International Criminal Court, now Assistant Crown Attorney at the Ministry of the Attorney General here in Toronto. Good to have you here at TVO.
Thank you very much for having me.
Well, just let's get the history on this. This is a move that's been many years in the making. How did we get from when this all began to today?
So Palestine became able to accede to the Rome Statute or sign on to the Rome Statute as a result of a resolution which was passed.
And the Rome Statute is?
The Rome Statute is a treaty which gave birth to the International Criminal Court. And that treaty is the treaty that was signed by a number of countries, 122 before Palestine's joining of the court. And Palestine became able to sign on to that statute as a result of a resolution which was passed by the General Assembly of the United Nations, whereby it gave Palestine the status of non-member observer state. And that was an upgrade from the status that it had prior to that, which was as an observer. And for the court and for the Office of the Prosecutor's perspective, Palestine's ability to join the court has always been determined by its status with the UN. And when it was granted the status of non-member observer state, it became determinative of the issue from the court's perspective of Palestine's ability to join.
Gotcha. And today's the day. Today's day one. So, as a result, the chief prosecutor of the court is going to look into Israel's military operations in Gaza last summer. And as a result, what kind of information are they going to be assessing as they undertake their investigation?
So at this stage, and what it is a preliminary examination. So it's a step well before an investigation. And it's an open and fairly transparent review of information that's given through various sources. It could be civil society organizations, NGOs, government and non-state sources of information about the conflict itself. And it's an opportunity for the prosecutor to decide whether the matter should move on to the stage of a formal investigation. So that's considering issues of jurisdiction, admissibility, and interests of justice.
Of course, the flip side of this is now that they're part of the ICC, they too can be the subject of complaints against them for human rights violations and so on. That exactly comes with the deal, right?
Absolutely. There's no insulating one's people or one's territory from scrutiny once you become a member of the court. You do expose your country to a review of the conflict that you're raising. And so one would certainly expect when the prosecutor is reviewing this matter that it will indeed take a look at the actions that the Palestinians allege are war crimes on the part of Israelis. But there's no question that the actions of Palestinians in this conflict vis-a-vis Israeli populations will come under scrutiny as well.
Well, now here's where it gets complicated, because Israel is not a signatory to all of this, right? So do they have to consent or participate in whatever investigations are to come?
That's a great question. They don't have to consent or participate, and in fact, they are under no legal obligation to do so. And it could very well prove to be one of the very frustrating aspects of this investigation from the point of view of the prosecutor, because in order to move forward with an investigation, and certainly in order to execute an arrest warrant for anyone, it does require cooperation from parties, because there is no independent police force and there's no other means of accessing potential suspects unless people work to execute arrest warrants and turn people over to The Hague to be prosecuted at the court. So while Israel can't block the Office of the Prosecutor from taking steps to move forward, practically speaking, the cooperation factor, or non-cooperation as the case may be, could prove to be very challenging for the court.
But Israel does care about international opinion, not to the exclusion of all else, obviously, but it does care about international opinion. Do you think that might be a card that the ICC could play to get them to participate somehow?
Well, it's a great question. I think that the ICC will likely, as it does with all conflicts, want to stick very closely to the parameters that are set up for it in the Rome Statute about how to proceed with the investigation and how to proceed with the trial stage. And so there would be a certain amount of public pressure on toward Israel to lend support, because there may indeed come a time when the focus of the investigation shifts to Palestine and actions that have been taken by Palestinians.
And then they would want, right.
And they would want they would want cooperation in that regard.
What's sauce for the goose is sauce for the gander, I think is the expression, something like
Exactly.
that. Are there, I'm sure there have been, maybe you could enumerate some of them, times in the past where countries which have been the target of investigations have just out and out declined to participate?
There have been certainly specific instances of countries failing to cooperate to the level where it has frustrated the process so much that the investigation or the prosecution has had to come to an end.
Like what?
So a notable example would be the prosecution of President Kenyatta in the Kenya situation, where the office of the prosecutor came to a point where it was no longer able to present sufficient evidence to the court to satisfy it that the case could go forward.
So they dropped the case?
So the case was dismissed. The investigation into the situation in the Darfur in the Sudan had to be suspended because of a lack of cooperation and issues related to collecting evidence. So those are the practical realities of the cooperation factor and the very serious effects non-cooperation can have on the court's ability to move things forward.
Do you think that affects the way the world sees the legitimacy of this court?
I think it very well could. One of the potential risk factors in getting involved in this conflict and other politicized conflicts is that the world might view at the end of the road, when there are people identified as being appropriate subjects of arrest warrants, if the court isn't able to move forward, either because it can't get cooperation or they can't get the people to The Hague to face trial, that it could be viewed as a failure on the part of the court to be able to carry out its mandate to bring people to account for alleged crimes. It's not necessarily the court's doing. There's not much of a mechanism for the court to force countries to cooperate and respect their obligations under the Rome Statute.
Court doesn't have its own army, does it?
It doesn't have its
Cannot
own
do it.
army, it doesn't have its own police force, and it very much is dependent on the 123 states members to assist.
You've heard this criticism before, but I'm going to read this excerpt in the Ottawa Citizen from a few months ago, and then I'd like your feedback on it. Since its founding 12 years ago, the ICC has indicted more than 30 individuals, but guess what? All are Africans. Only 2 have been convicted. If you follow the ICC's idea of justice, the only conclusion to be drawn is that over the last dozen years, only Africans have committed war crimes and crimes against humanity. Yet, human rights organizations have documented numerous alleged war crimes or crimes against humanity by several countries, including the US, Israel, and Egypt. There have been no indictments. Your reaction?
Well, it's a fact that there have not been indictments of Americans, Israelis, or Egyptians by the ICC, and the reality is that that hasn't happened because none of those countries are parties to the Rome Statute and members of the court. The court is restricted in its ability to be able to do justice in any situation by the Rome Statute, and it requires parties to accede or agree to accept the authority of the court. And so it is not the case, in my view, that the court is focused on or targeting African countries. I don't think anyone would dispute that the situations in Africa that the court is pursuing are valid situations where there are gross human rights violations and crimes that are of concern to the international community happening. That there are those kinds of crimes potentially happening in other areas is also indisputable. But the question becomes, can the court access those countries in those situations where the country is not a state party and where the Security Council has not intervened by way of putting the matter to the court? And that's the situation with, for example, the United States or Israel or Egypt, is that there just isn't a mechanism by which an investigation can be launched short of Security Council intervention.
Do you accept the fear that I think the American administration, the Israeli government, and so on put forward, which is, if we sign this thing, if our head of state or head of government goes somewhere in the world, they could be, who knows what, arrested by an unfriendly government and then end up in The Hague, and they don't want that, obviously. I mean, is that a legitimate concern on their part?
Well, I think that when you become a member of the court, you're not insulated from investigations. And if an investigation should give rise to a basis to believe that some of your nationals have committed war crimes or crimes against humanity or genocide, then there is a legitimate possibility that you will be apprehended by a country that has an obligation to turn you over. But I think it's quite important to remember in this conflict and in all conflicts that it's very much a step gradual step-by-step process. So right now, the prosecutor is doing a preliminary examination into the matter, which is a transparent, open-ended, exploratory exercise.
How long will it take?
It could take years.
Years?
It could take years. There are several situations before the court now which are in the preliminary examination stage. Colombia, Honduras, Ukraine, to name a few, Nigeria. And in some instances, Colombia as an example, it's been going on for 10 years and it continues to go on. And the reason for that is because where the Office of the Prosecutor sees progress in those countries in terms of those countries taking steps to investigate or prosecute possible crimes, it's the principle of complementarity requires that the court step back and let the national proceedings play through because they have primacy over the court. The court is the court of last resort. So the examination stage will take as long as it takes the prosecutor to be satisfied that all three criteria of jurisdiction, admissibility, and interest of justice are met. And then that just brings us to the investigation stage.
So while this is a red letter date for Palestine in some respects, on the other hand, it doesn't sound like we're going to be seeing any Israelis or Palestinians in the docket anytime soon. That sounds like a yes.
Anytime soon, I would say no. It's a long process. We're in the very, very early stages. And with all the considerations of cooperation that will be in play, or non-cooperation that will be in play in this situation, it could be a very long time.
Rita, it's good of you to come in tonight and help us out with this. Thanks very much.
My pleasure. Thank
Rita
you for
Maxwell
having me.
from the Ontario Ministry of the Attorney General.
Support Ontario's public television. Donate at tvo.org.